Good morning, everyone. Welcome to Assembly Judiciary. With that, Secretary, please take the roll.
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Considine.
Present.
Assemblywoman Gallant.
Here.
Assemblyman Gray.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman LaRue Hatch.
Here.
Assemblywoman Marzola.
Here.
Assemblywoman Mosca.
Here.
Assemblywoman Newby.
Here.
Assemblyman Ortlicker.
Here.
Assemblywoman Summers Armstrong.
Present.
Assemblyman Urick. Chair Miller.
Here. And with that, just a few reminders, asking everyone to, again, turn off their electronic devices, making sure that when you do speak, if you're presenting or testifying, that you say your name and spell it so we have it accurate for the records. Of course, we will have a work session at the end of today's hearing, or today's meeting. We have today scheduled one bill hearing and 6 work session items. There were 7, 160 had to be pulled because of a last-minute amendment that got submitted. So for everyone out there in the world concerned about bills, please make sure you're getting these amendments in well before they're posted for work session. Because again, it's difficult for members to get an amendment and have to digest and review and even possibly reconsider bills when there are late submission amendments. So with that, we will begin with our work session. Ms. Diane Thornton will walk us, our policy analyst will walk us through the first work session.
Thank you, Chair. Diane Thornton for the record, Legislative Council Bureau. Our first bill on work session today is Assembly Bill 49, is sponsored by the Assembly Committee on Judiciary on behalf of the Attorney General and heard in committee on February 22nd. This bill prescribes separate and distinct forms for a petition for a writ of habeas corpus that challenges the computation of time that a person has served pursuant to a judgment of conviction and a petition for a writ of habeas corpus that challenges the validity of a judgment of conviction. The bill also repeals the requirement that the respondent on a post-conviction petition for a writ of habeas corpus file a return with the court. There's one proposed amendment to the bill. Heather Proctor from the Attorney General's office proposed the following. First, amend sections 2, 4, 6, 7, 9 through 12, 15, and 19 to clarify judgment of conviction rather than conviction throughout the bill. Amend Section 2 to provide a definition of prosecuting attorney. Amend Section 3 to provide additional instructions to clarify that the form should be used if an offender is seeking relief based upon the computation of time served, a forfeiture of credits, or a denial of parole. Amend Section 3 to clarify that the form is not for challenging the calculation of time, and the petition must include facts supporting the grounds for relief. Amend Section 9 to provide that a petition that challenges a conviction or sentence may be filed within 1 year under certain circumstances. Amend Section 11 to clarify instructions that the form should be used if the offender is seeking relief from a conviction or sentence and not for the challenging of calculation of time. Amend Section 11 to clarify in the instruction what information may be submitted. And lastly, amend Section 11 to require that one copy of the completed petition must be mailed to the prosecuting attorney, and the amendment is on the following pages. Thank you, Chair.
Thank you, Ms. Thornton. With that, members, are there any questions? Not seeing any questions, I will entertain a motion to amend and do pass.
Motion.
I have a motion to amend and do pass by Vice Chair Marzola. Do I have a second?
Second.
I have a lot of seconds. All right, we'll take a second from Assemblyman Urick. With that, is there any further discussion on the motion? Not seeing any. All those in favor, please say aye.
Aye.
Anyone opposed? And the motion passes unanimously. Great. I will assign that floor speech to Assemblywoman LaRue Hatch. You're welcome. Ms. Thornton, will you walk us through Assembly Bill 75?
Thank you, Chair. Assembly Bill 75 was sponsored by Assemblyman Yeager and heard in this committee on February 13th. This bill provides an exemption from state registration requirements for certain transactions involving an offer to sell or sale of a security to a Nevada certified investor. There's one proposed amendment to this measure. Assemblyman Yeager proposed amending Section 2, subsection 1 of the bill to change the registration requirement so that business must exceed 2.5 times the median income, or 200,000, whichever is higher. It amends Section 2, subsection 2 of the bill to change the certified investor threshold from exceeding median income to 100,000 or exceeding median income, whichever is higher. Increases the threshold for exemption from registration for sales to certified investors to 75 or fewer individuals, but requires a background check for the issuer similar to what is in NRS 391.033 for educators. It removes all registration fees for NRS 90.490, and it amends the existing language of NRS 90.490 by revising the required information in the registration statement. Thank you, Chair.
Thank you, Ms. Thornton. Members, are there any questions? Not seeing any questions, I will take a motion to amend and do pass. I have a motion to amend and do pass Assembly Bill 75. Do I have from Vice Chair Marzola? Do I have a second? Second from Assemblywoman Newby. Members, are there any further discussion on the motion? Assemblywoman Summers Armstrong?
Thank you, Madam Chair. I just wanted to let you know that I'm in discussions with Speaker Yeager about some consumer protections that I was concerned about that have not been addressed. And so I will vote no today, but I am still open as we get these things hashed out to deal with those consumer protections that I discussed in the hearing and also discussed with him today.
Thank you, Assemblywoman. We always appreciate when someone will say that they will vote yes out of committee, but may reserve the right to change the vote. We always are very open to people changing their votes to yes on the floor, so thank you so much. Any further discussion, members? Okay, not seeing any. All those in favor, please say aye. Aye. Anyone opposed, please say nay. Nay. Okay, so we have 2 nays. So we have a nay from Assemblywoman Summers Armstrong and a nay from Assemblyman Orrin-Licker. With that, the motion passes, and I will assign the floor statement to Assemblywoman Gallant. You're welcome. Next one. Ms. Thornton, Assembly Bill 260.
Assembly Bill 260 is sponsored by Assemblyman O'Neill and heard in committee on March 16th. This bill exempts veteran service organizations and any agent or officer of a veteran service organization from certain business fees, including the issuance and renewal of a state business license, filings required in connection with the registration of a registered agent, and various filings to satisfy requirements imposed on a business entity. And there are no amendments to the measure. Thank you, Chair.
Thank you so much. With that, members, are there any questions on Assembly Bill 260? Not seeing any, I will entertain a motion to do pass. Okay, I have a motion from Vice Chair Marzola and a second from Assemblyman Gray. Any further discussion on the motion? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? All right, the motion passes unanimously. And Assemblyman O'Neill, you will have that floor statement. You're welcome. Thank you so much. Next bill, Ms. Thornton.
Assembly Bill 272 establishes provisions relating to mail theft, sponsored by Assemblywoman Monroe Moreno and heard in committee on March 28th. This bill establishes the crime of mail theft. A person is guilty of the crime of mail theft if the mail has no monetary value and does not include the personal identifying information of any person, a gross misdemeanor. If the mail has monetary value or contains personal identifying information of not more than 9 persons, a Category D felony, or if the mail contains a personal identifying information of 10 or more persons, a Category C felony. There's one amendment to the bill. Assemblywoman Monroe Moreno proposed doing the following. Amends Section 1, subsection 1 to provide that a person commits the crime of mail theft if the person buys, receives, conceals, or possesses personal identifying information and knows or reasonably should know that the personal identifying information was unlawfully taken or obtained, and amends in Section 1, subsection 2 the penalties of mail theft by providing that a person is guilty of a Category D felony and shall be punished as provided in NRS 193.130. Thank you, Chair.
Thank you, Ms. Thornton. Members, do we have any questions? Not seeing any questions, I will entertain a motion to amend and do pass Assembly Bill 272. I have a motion from Vice Chair Marzola. Do I have a second? I have a second from Assemblywoman Gallant. So I will go ahead and, I'm sorry, any further discussion on the motion? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? Okay, the motion passes unanimously. And I will assign that floor speech to Assemblywoman Monroe Moreno. Ms. Thornton, will you walk us through the next one?
Assembly Bill 350 was sponsored by this committee and heard on March 24th. This bill requires each law enforcement agency to include certain additional information relating to seizures and forfeitures in the report that law enforcement agencies submit to the Office of the Attorney General. This bill additionally requires the Office of the Attorney General to make the reports relating to the seizures and forfeitures that are published on its internet website available in a machine-readable format, and there are no amendments to this measure.
Thank you, Ms. Thornton. Members, any questions on Assembly Bill 350? Not seeing any, I will entertain a motion to do pass Assembly Bill 350. I have a motion from Vice Chair Marzola and a second from Assemblywoman Newby. Is there any further discussion on the motion? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. I will assign that floor speech to Assemblyman Urick. Ms. Thornton, will you walk us through the last motion, please?
The final bill on work session today is Assembly Bill 388, which makes an appropriation to the Department of Sentencing Policy for the purpose of funding certain grants awarded by the Nevada Local Justice Reinvestment Coordinating Council, sponsored by Assemblyman Yeager, and heard on March 31st. And there are no amendments to this measure. Thank you, Chair.
Thank you. Members, are there any further questions on Assembly Bill 388? Not seeing any, I will entertain a motion to do pass Assembly Bill 388. I have a motion to do pass from Vice Chair Marzola. Is there a second? Second from Assemblywoman Constantine. Is there any further discussion on the motion? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? Okay, let's go ahead and get a count so we see Assemblywoman Hanson, Assemblywoman Gallant, Assemblyman Urick, Assemblyman Gray, Assemblywoman Hardy. So are you also saying none of you want the floor statement? I will go ahead and assign that floor statement to Assemblywoman Mosca. You're welcome. All right, so that concludes our work session for today. Thank you, members. Next on the agenda is our one hearing for the day, Assembly Bill 452. It will be presented by Assemblywoman Newby and Ms. Jody Hawking, and I believe Mr. Nick Shepak. And with that, Assembly Bill 452 revises provisions relating to visitation with offenders in a correctional facility or institution. With that, your hearing is officially open, so once you all get settled, please feel free to proceed.
Thank you, Madam Chairwoman. For the record, I am Sabra Newby, Assemblywoman from District 10, and we are before you today to present AB 452, which is a bill that came out of the Joint Interim Standing Committee on Judiciary. It concerns visitation of friends and family members in the prison system, and I've been working with Ms. Jody Hawking to my left, your right, from Return Strong, and Mr. Nick Shepak on my right. Your left, also on this bill. We do have a conceptual amendment that we turned in that has the wrong title on it. It says AB 462. It is actually 452, so apologies for that. But I'm going to turn it over to Ms. Hawking or Mr. Shepak to talk about the way that we got to this point and the conceptual amendment and the reason for it.
Good morning, Chair and committee members. My name is Nick Shepak. I am the State Deputy Director of the Fines and Fees Justice Center and the Board President of Return Strong. I am going to leave it up to Ms. Hawking to get into the details, but I briefly wanted just to discuss how we got here and why we landed on this, what is now a very conceptual amendment. Through many talks with the Department of Corrections and stakeholders, we determined that an ombudsperson, instead of heavy regulations surrounding visitation, would address most of these concerns as well as many other concerns. And we believe that a statewide ombudsperson is an answer to address countless issues, and we have agreement that this can work from all stakeholders. And so these discussions went late into the night leading up into this hearing, hence the very conceptual version of this amendment. And I will pass it over to Ms. Hawking to explain further.
Good morning. As you know, my name's Jody Hawking. You all know me as the founder and director of Return Strong. I'm also a constituent of Assembly District 24 and Senate District 13. But I want to just take a second and remind you that during this presentation, I'm also a woman whose loved one, my partner, my best friend, is in prison and who spent the majority of his life there. He was born in prison addicted to heroin and crack, and the imprint of that on him and his family has been a cloud for a very long time. As I move through this presentation, I want you to remember that while this is professional for me, it's also deeply personal. And some of what I'm going to share has been extremely traumatic, not just for myself, but for families, children, and the loved ones of people who are incarcerated and their families. Bringing an end to that is really what we're hoping to achieve through this bill. I thank the members of the Interim Judiciary Committee, Chair Miller, and Assemblywoman Newby for hearing our voices and bringing this really important piece of legislation forward. I want to take a second and kind of piggyback on what Nick was explaining and how we went from a very restrictive bill that was really was meant to address very specific issues that we were having problems with. I wrote this all out at 3 a.m. and now I'm going to end up going off. But when we originally started working on this bill back during the interim, we were in a very different situation. There was a different administration. There were issues with families flying across country for visitation and ending up standing at the door with a sign on the door that said, "Your visit's been canceled, visiting is closed," whatever that situation was. And it was very, very difficult. We had already lost visitation for 1.5 years due to COVID. When it reopened, everything gradually just fell apart. Not only just the showing up and visiting being closed, applications weren't processed, children were removed from visits for hugging a parent that they hadn't seen in years. There was just a lot of horrible things going on, and this bill started as really a desperate cry for help to find solutions to it. But ultimately, that help in part came from new administration and the changes that have happened, and Director Zarenda and Deputy Director Wickham being back. I know I've talked to enough people to know that really, like, our interactions with him are really like a sigh of relief. Like, it really is good to know that he will listen and help us. But at the same time, we have to he's helped us really move from this very narrow perception of what would be like, how do we make them give us 72 hours notice for a visit, to how do we really solve these problems in the long term. And so I just want to acknowledge that they've been a big part in helping us figure out a way to do this. What this bill would do is actually, it would require the directors to submit an RFP to implement a search for an ombudsman with a certain number of days. I don't think we've agreed on that yet. Of the bill passage. The ombuds would be responsible for overseeing offender grievances, disciplinary appeals, and visiting appeals, as well as training and oversight and monitoring the record keeping and timeframes that would be put into effect through this bill. The ombudsman, the goal is that they would really be a last step mediator for these areas prior to filing for litigation and would follow national best practices for correction ombudsman. This idea of a corrections ombudsman isn't foreign in Nevada. In 2011, Nevada passed NRS 209.244, which gave the Attorney General's office the option is keyword, to create a pathway to mediating complaints from incarcerated people, but the statute was never funded and consequently has only been words in a legislative digest somewhere, something that could have been but never really quite materialized. Together with the director, we've been able to actually find a pathway to make this happen. I want people to not only understand that there's a pathway to make it happen, I want to give you a glimpse of why we were here in the first place. Some of the things that were happening. In our work, we correspond with almost 1,500 incarcerated people at any given time, sometimes more than that. And we constantly have our finger on the pulse of what's happening inside NDOC from a network of people that have worked with us to organize from the inside out. It's pretty rare, but it has allowed us a really unique perspective into what happens inside Nevada prisons. I'm going to share some quick examples of things that occurred that brought us to this point, just so that you have an idea of how an ombuds could help, how they would have made these situations different. And I just want to remind you one more time that behind each one of these stories are families and children and parents and grandparents who were dealing with the trauma of these events at the same time. Michael Kiliakolo lost his fingers in a tragic in-cell accident at Southern Desert, but he ended up with gangrene and almost lost his life because he never received wound care while he was in the medical unit. The family of Sony Pham is a man who was in his young 30s, whose family called us in desperation because he was in the ICU dying of COVID. The doctors were saying he wouldn't make it really through the night. His parents and twin sisters were trying to visit him and say their goodbyes, and the hospital said they could come, but they needed approval from NDOC. Administration at the time wouldn't answer their calls, and we ended up intervening and were able to get a hold of a warden and convince him to approve the visit. But what would happen if we weren't there to fight for them? And ombuds could have been a person that they could go to, and it wouldn't have been just like a wild shot in the dark. Jordan Blackwood is a young man who went to prison in his teens, and he's incarcerated during COVID, during the outbreak at Warm Springs in 2020. Jordan's cellie had COVID and turned blue and passed out in the cell. They were screaming for help from the whole unit, and a CO came over the intercom and told him to perform CPR on his cellie. No one ever came to help either one of them. Every year in multiple facilities, there are issues with no heat, hot water, air conditioning. Imagine being in a cell when it's 117 degrees in Las Vegas outside and the AC is blowing heat. That might not be really how it works, but the heat's blowing from wherever it's coming from. Our buildings and infrastructures, and Director Zarenda has said the same thing, are falling apart. We've tried everything to have it addressed, but no one ever responds. An ombudsman could evaluate that and find pathways to resolution through capital improvement or other recommendations. Monica's a woman who was at Florence McClure Women's Correctional Center. She sent us over 30 letters. She's now free, but day after day, she would beg us for help. She'd write these scratched letters with "help us." It used to look like a car with, in a bad movie that someone just got kidnapped, that would say "help us" on pieces of paper and send it to us every single day. She told us stories of women being abused and mentally broken at Florence McClure by the lockdowns, by abuse, by a wide variety of things. She wrote us a letter about a suicide of a young woman at Florence McClure and many attempted suicides, including one where the woman had cut her wrists and used her blood to scrawl "this is your fault" on the walls of her cell. Esteban was a young man in his 20s, doing his first sentence ever, who died of E. coli. They had served lasagna in the chow hall, and that whole unit got sick. A lot of people got sick, but Esteban died. He was ignored by medical staff for 5 days. He was given a COVID test and nothing else. By the time they did anything, he was unresponsive. By the time they got to the hospital, he was dead. the attack on incarcerated people in the Chow Hall at Southern Desert last summer, which was described by people who could see what was happening as an ambush. Cameras were covered, weaponized officers stormed Chow Halls, and ultimately we received stacks of letters from people who were not in the Chow Hall but could see what was happening, and witnessed a person who was handcuffed on the ground being beaten and kicked in the head, who has resulted in a traumatic brain injury and criminal charges for that officer. Grievances and the grievance process for anybody who works in law are taking years to make it through that process, and the system is overwhelmed with due process violations that make resolution impossible in any timely manner. Two more. A recent incident that thankfully Director Zarenda very quickly helped us address and work to get corrected from the previous administration, but people were notified that people who had received disciplinary write-ups for things like a fight, where nobody was seriously injured or no one needed medical treatment, were charged with murder as their disciplinary write-up. I couldn't really believe that it was true, but it was. The previous administration had made changes to a disciplinary manual, removing several levels of sanction, and consequently, my understanding is then anybody who had anything that fell in the middle was getting notice charges about murder. Even though there was no murder victim, there was no body, and no death had occurred. Thankfully, Director Zarenda very quickly resolved that and fixed that problem. But if he hadn't have been here, we would still be stuck with people facing murder. The never-ending lockdowns at multiple facilities. Post-COVID, while many of us have gone back to some semblance of normal life, that never happened in NDOC. Lovelock, High Desert, Florence McClure, and Ely all still experience extended stays where they're 22 to 23 hours a day in the cell, even though they're not disciplined. A lot of it has to do with staffing, but they spend the bulk of their days in de facto solitary confinement. The point of these examples that each of them could have been resolved with an ombudsman and potentially resolved without a lawsuit or settlement that continues to cost the state money. Prisons need oversight, and not just in the form of lawsuits that are long, tedious, and often blocked by the Prison Litigation Reform Act and due process violation. Legal protections are a form of external oversight, but prisons need layers of oversight and accountability in order to ensure that prisoners are safe and treated humanely at a minimum. An ombudsman in Nevada would, sorry, I lost my train. What an ombudsman would be like in Nevada is our decision. There are 18 states currently that have enacted legislation around ombudsman, but what that looks like fits the needs of that jurisdiction. We have an opportunity to work together to decide exactly what it will look like in Nevada, but there are some best practices that have been recommended by FAM, the Marshall Project, the Veer Institute, and the Brennan Center. They include things like ensuring that the ombuds is run independently from corrections in the AG's office, making sure that the ombudsman has the ability to enter and inspect facilities without notice in order to investigate complaints, as well as have access to documents and data relevant to their work. The ombuds would be responsive to families, incarcerated people, the public, and legislators and decision makers. They would report findings and make recommendations. This amendment, conceptual amendment, creates a win for incarcerated people and families, a win for NDOC, and a win for the state. Thank you for hearing this bill, and we look forward to your support.
Thank you for that. Assemblywoman Newby, are you going to walk us through the, thank you.
Yes, Madam Chairwoman. Just to walk through the bill as written today, Section 1, of course, says that there's going to be new sections added to NRS. Section 2 sets forth the directions that the director will adopt regulations concerning visitation that will be done in each institution, and then goes forward to line out what those regulations would include around visitation. So subsection A, the frequency, and then the subsections in that to talk about how often these visitations should happen, and also gives direction on how if vendors who gave birth at any time during the 6 weeks, what those visitations should be like and the frequency of all of those. And then it goes on to subsection B, the eligibility of offenders to receive visitors, and requires that there be regulations around that. Subsection C then goes on to approval or denial of a prospective visitor, requires that regulations be written around that as well, including notice and appeal process and a procedure for appeal. Subsection D is the notice around a canceled visit. You had heard some testimony today about what happens when a visit is canceled unexpectedly. And so subsection D goes through and requires certain regulations to be written around that. Subsection 2 then, Madam Chairwoman, do you want me to go through this in that level of detail, or do you want me to just kind of give an overview?
I think an overview is fine.
Okay.
Then members will ask questions if they have more detailed.
I was starting to see pain on all of your faces, so.
No, yeah, I think you're seeing Friday after a long hearing last night, and people just, thinking about their flights. But please
Right,
don't take that
okay.
personally.
Okay, I won't. In summary, Section 2 talks about regulations that need to be developed and implemented. Section 3 talks about a review panel to review, it sets up who should be on that panel, and then the duties of that panel and what they should review if someone is denied, and any appeals that come through. And then it goes on to Section 4, and Section 4 really talks about those denials, what happens when someone is denied, and what sort of information must be given to that person to kind of close that loophole where people are denied but they aren't told why they are. So there you go. I think Section 5 makes conforming changes, and Section 6 is the effective date. As we mentioned, as Ms. Hawking mentioned, she has the conceptual amendment. My understanding is that there is another piece of legislation being considered in the Senate that also concerns this, this area of law. And so the conceptual amendment was to get at the sort of a mediation of these issues with the ombudsperson, understanding that there was also other legislation pending in this particular area as well.
And thank you for mentioning that, but again, we can only consider the measures in front of us
Understood.
because we know, the shelf life of bills here and what may or may not. But thank you for adding that as a consideration. Mr. Shepak?
Thank you, Chair. Nick Sheepak for the record. I don't have much to add at this time. I'm here to answer questions. I will just state that the proposed amendment would redline the bill, replacing it with the ombudsperson.
Thank you for that. And because we just received the amendment this morning, members have been asked to consider this measure in both regards, as written and then as a gut and replace with the new conceptual amendment, because it is difficult for us to get it and then consider. So we're actually viewing this through both lenses, okay? And I see that Director Zarenda is here, so I also know that you are available if members have questions as well. Thank you. I love when there's people in the audience that I know are always going to step up and say absolutely without me. So I don't feel like I'm putting you on the spot because I know your nature. With that, are you open for questions? Okay, great. We do have a few questions. So first question will be from Assemblywoman Gallant.
Thank you, Chair. Oh, good. My question is for you, Director. So I'm glad you're sitting here. First of all, I like the intent of this bill in terms of making sure that there's a visitation with the outside world. And we've seen a lot of bills and hearings about the importance of having connection and reducing recidivism. So I do appreciate that. However, after spending, how are we, 56 days into the session? I'm sorry, 60. Okay. I have learned that as much as I am able to control my life at home and have less emergencies and my schedule being changed, that hasn't been the case the last 60 days. And I imagine within the department, within the prison system, that there can be some times where emergencies come up. And so I'm wondering, in terms of this section, what is this, section 131, am I reading that correctly, where it says provide at least 72 hours prior to like advanced cancellation? Is there going to be anything in terms of exceptions to that rule if there is an emergency at a particular facility?
So James Renda for the record, Department of Correction Director. Majority of our cancellations happen at the last minute. They are not 72 hours. Cancellations happen when there's reduced to the lower than minimum amount of staff required to run the actual facility, or that there's a emergency that happens at the facility, whether there's a disturbance, when something happens, there's a lockdown because of a potential escape. It could be a whole variety of things, but very few are actually canceled at 72 hours. The majority are at the last minute of operations.
Sure.
So if this was to be enacted as is, what is that going to look like for your department? I mean, is that going to back you into a corner where now you're having to juggle safety versus breaking this statute?
James Renda for the record. So if we know that the visits are going to be canceled at 72 hours prior, it should be posted, and we will post them, and we should be doing that now anyway. But like I said, the majority, we don't even know until the last minute. When we do, what will help, when we do get eventually tablets, wireless devices, they can be put right on the wireless devices and notify them almost immediately that cancellation of visits have occurred.
Thank you. Ms. Hocking?
Jody Hocking for the record. I just want to add something to that. So we understand that, obviously there are staffing and emergencies and things like that. There is a part of that bill that says that if it's less than 72 hours notice, that the director has to sign off on that. Because clearly we understand any of those things. I was traveling from New York for visits for decades, and there has been a significant increase in that happening, and there are just ways around making that like a middle ground. So, there have been recent incidences where visits were canceled for really unclear reasons, and so all we wanted was, if you can't give 72 hours notice, like for instance, Washington does like a traffic light on their website, so you can check your loved one's facility. They're red, there are no visits that weekend, don't travel. There's yellow, check with the institution, it's green, you're good to go to visit. And so we were hoping to eventually have some type of system like that, and that he has this one has the authority to override that, because clearly, like he just said, there are instances. So we did have that also included in that.
Thank you for that. Our next question is from Assemblywoman Mosca.
Thank you, Chair, and thank you for this. When reading it, my question was on Section 3 about the review panel. I appreciated that it included who was on it, but I didn't see about, what was your intent of how long they would have to go through it and when you wanted a response.
That plan for the review panel was really to, the way that the appeal process happens right now, it was shutting down opportunities way before, so it wasn't like really giving people a fair shot at having their cases looked at. Can you repeat what your question was? Because I feel like I'm just randomly answering my own question.
Yes, thank you. It was just what's your intent that the review panel, do they have 2 weeks to meet and make a decision, or just the time?
I don't think we had a time frame in mind because it depends on how it works, and there are significant changes right now that are happening that, this is why the ombuds bill is hopefully gonna be where this goes, but, that Director Zarenda is working with us on providing input on a new visitation manual, which would address many of those things outside of statute, and, that we would work together on those pieces.
Next question from Assemblywoman Hanson.
Thank you, Chair, and good morning. Certainly, having served here for a little bit and also having watched from afar for many years, there certainly is a need for this. So thank you for bringing this. I do like this versus the original part, and I'm hoping maybe that's where you're going to land. An ombudsman seems like it's been something we've needed for a long time. So I think, Mr. Shepak, you mentioned there were other states, and maybe there were 18. I just want to make sure I got the right. Are there other states, or maybe you did, Ms. Hawking, I'm sorry. How many states, if you could reiterate for my notes, how many states, and if you happen to know what those states are that have an ombudsman? Unless maybe you were citing something else about the states and it was an ombudsman.
Jody Hocking for the record. I believe that is 18 states, and I sent, there's an exhibit that lists all of them. I know that there have been new ombudsmen in Connecticut, New Jersey. There's several states that have recently added them, and each one seems to do it a little bit differently, which is why I think there's a clear path to us figuring out what works for Nevada in Nevada. But as a general, the document is in the exhibit, and it lists county jails and all different ways that ombudsmen are being used across the country.
Follow-up, Chair? Proceed. Thank you. And my apologies, I didn't even look at that yet. So we've been focused on guns and work sessions, so I apologize. One of those states mentioned, I think, might have been Director Zarenda, maybe a state that you're familiar with. Can you opine a little bit on that model?
Sure. James Zarenda for the record. Connecticut, and even when I was commissioner for Connecticut, running the prisons and jails in Connecticut, we did have ombudsmen. Ombudsmen actually, when you even talk to anybody, any states that have them, they actually do reduce litigation cases. Currently in the state of Nevada, there are over 600 litigation cases against the Department of Correction as of today, which is overwhelming the Attorney General's office. Ombudsmen that can be a nonpartisan party of individuals that are looking at cases of grievances. If you know anything about litigation cases with corrections, they have to go through grievance process first before it goes through the court process. Having those bypassed by an ombudsman would actually be able to prevent a lot of these cases that are going into the Supreme Court now from getting to that far. And it would also help reducing a lot of the caseloads of the deputy attorney generals who I've met with about this specifically. So it would be a benefit to them as well, as long as there's a funding source. And funding sources can actually be mitigated by having a long-term reduction in litigated cases can actually save more money. So it's hard to predict that, but I know from experience in Connecticut that helps. It also reduces any anxiety or tension with the offenders, knowing that someone outside the agency is actually reviewing and looking at cases that are grievable, whether it's visiting appeals, whether it's any grievable cases on property, which is our #1 grievance issue, talking about conditions of confinement, which are grievable issues that can all go through ombudsman if one did get developed in the state. I do think it'll be a benefit for the agency if we're able to do something similar.
Thank you. With that, our next question is from Assemblywoman Cohen.
Thank Thank you, Chair, and thank you all for the presentation. Okay, so I'm a little, I guess I'm still kind of confused about what the intent is, because I think of the bill as getting regulations to put together the program for visitation, right? And making sure all the families and the offenders know what the program is going to be and when they're going to, everyone's going to be able to see each other, what those standards are going to be. But ombudsman is more about investigating, right? That's the, they're appointed to investigate complaints. So are we trying to do both? Are we trying to do one or the other? Because if there's an issue as far as, someone who's incarcerated saying, I'm not getting my visitation and and it's not appropriate, or I'm not able to see my family for whatever reason, aren't there caseworkers they can be going to? I'm seeing this kind of two separate things, and where I think both are noble goals. I don't know if we're trying to do both with this or one or the other.
Jody Hocking for the record. So at this point, what we're really looking for is an ombudsman. The original language and the kind of like nickel and diming was to try to hold NDOC accountable to their visitation policy, and there was no way to do that before. Ultimately, if I have an issue, if an ombudsman is able to hear things that violate policy. So if we negotiate policy and get that approved so that the policy is set, right, which that's been part of the problem is that it hasn't been, we do that through the AR process and through getting approval from the Board of Prison Commissioners. Once that is set, an ombudsman would be able to hear any grievances or concerns. If we're like, you know what, every Saturday at High Desert, visitation gets canceled for people at the door because of staffing, then we can sit down and have a conversation, or can go through the ombudsman to investigate why there is a problem there and then provide a recommendation to how to get it corrected. They become a neutral third party in that process. So this is kind of two things, is that we now have an avenue to actually just negotiate the ARs and the policy around visitation, which will be part of the correction, and then the ombudsman provides a neutral third party for accountability. You guys want to add anything to that?
Nick Sheepak to the record. Just to add to that, having done this now for a few sessions and spent a lot of time working with corrections, there are many laws on the books for years that we have felt have not been followed. Organizations such as the ACLU have the ability to litigate that. However, if we put regulations in and in a future date those regulations are not followed, the recourse to figure out what to do about that is almost solely through litigation. It's been very difficult. There's been no oversight. So even if the visitation policy makes sense and everybody agrees to it, if it's not being followed, there's no real path for recourse. If we create an ombudsperson, even with the current standing policy for visitation, it would ensure that those policies are followed, and it would give families the recourse in a much more immediate fashion than going through the long, arduous process of trying to file litigation to ensure that any department in the state follows the regulations that this body sets or the administrative regulations that they set themselves.
Thank you. Our next question is from Assemblywoman Summers Armstrong.
Thank you, Madam Chair, and thank you very much for the presentation. I have concerns. I was on the Interim Judiciary Committee, and I sat through those hearings last year. And this bill is a result of those hearings and what we heard in 21 and in the interim. And I'm concerned about dismantling it. So my question to Director Zorinda is, do you currently have resources, one, for technological updates to assist with helping people be notified, as I'm so sorry, I just had Ms. Hawking, I'm so sorry. I'm getting that age, y'all. Stuff just pops out. Ms. Hawking is discussing about updating your processes for notification. So if we went along with the ombudsman, and do you have the resources to make updates to your computer system, to your notification system, to address these things? And do you have the resources to even fund an ombudsman that would then take care of all these things?
James Renda for the record. So right now, we're in the process of hiring a public information officer, which the agency does not have right now, who would be the individual that's in charge of the Department of Corrections website, which I believe wasn't updated in the last 2 years. That's one avenue of notifying anybody. The other way of notifying everybody would be just notifying the offenders, and hopefully the emergencies aren't in their units. They would be able to at least notify people through their phone calls. In the future, the ombudsman we don't have funding for it, but there are ways of funding. If it's not through general fund, it could go through inmate welfare fund, because it is a service that's available. It meets the criteria because it's available to all offenders for the purpose of them. The issue with technological devices, again, when we get a wireless devices to every offender, it's going to be immediate to them and their families. And that's really, I think, is going to be, like I mentioned in AB 35, it's a game changer for the agency and for the state, having these wireless devices with communications to the families almost immediately.
When we spoke about that bill with the wireless devices, one of the questions that I asked was, yes, they're available, but there's still a cost, right? So there will be some folks who are incarcerated who will not have access to communicate because they will not have the resources to do so. So please clarify for me, if an incarcerated person does not have the resources to communicate with this device, and your website hasn't been updated in 2 years, and you don't have the finances necessarily to make the changes, we're just going in a circle. Please clarify for me.
James Renner for the record. If listen to my testimony on AB 35, having those wireless devices with certain things that have charges to them, whether it's entertainment, videos, gaming, that are not something that everyone needs to have or could have if they pay for them, those services and those fees would actually pay for free phone calls for every offender. That's how you would be able to. When the offender has the wireless device in their actual cell, the second they hear that they're canceled, they can call immediately with they get one free phone call every day if those wireless devices are enacted as was proposed. So it does allow for emergency immediate communication free of charge for every offender at least once a day. The public information officer, yeah, it's going to be a great website, but if we lose the public information officer because they find another job and we go through the process again, yes, you're going to be stuck with another issue with the posting having an immediate and could be troublesome.
Thank you. Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for addressing these issues today. I know we've been talking about them a lot over the last several weeks. I wanted to dig in a little bit into the actual language of the bill. I know on page 3, there's subparagraph 4, it talks about the 5 consecutive days of in-person contact for children less than 1 year of age. And then on the previous page, there's also the 2 in-person days for an offender that gave birth, and then it says that they don't affect the other. So I just want to confirm, does that mean for the first 6 weeks of a child's life, they would have everyday contact with their parent? So I want to confirm that, 1, and then 2, I'd just like to know what is the current policy on someone that has recently given birth?
James Arenda for the record. So when someone has been given birth, the policy is the same with everybody. You get up to 2 visits a week You visit as soon as they're approved on the visiting list. What they do 5 days a week, infrastructure-wise, I don't know how we would be able to do it, what sizes of the facilities, because we're even talking male facilities. High Desert has approximately a little under 4,000 offenders. Depending on the numbers, we don't have infrastructure big enough to be able to provide all those visits. And mixing populations is a difficult thing too. If you mix a high security with a low security just because they had a child, could be dangerous to the family and to the individual. So there may not be, on my end, it's very difficult to even try to find a way to be able to do that. And if you increase the amount of visits, then we would have to find the increased amount of staffing that could actually provide those services to be able to escort, to be able to monitor, sign in, backgrounds, all that will require staffing. But right now, when you have the communication with the child, if we had a woman that was pregnant in the facility and they give birth, even if it happens at the facility, the baby is removed from the offender and turned over to either whatever was agreement with the family, the other either spouse or significant party, or the Department of Children and Families.
And Nick Sheepak, for the record, to address your first part of the question, you're reading that correct. That is a policy that is proposed. It is a policy that we believe is good policy. I will say through many discussions, though, I do have to concede that the feasibility of implementing such immediately does appear to be quite a hill to climb. However, we stand behind the intent of that policy for children and their parents.
Thank you so much. Our next question is from Assemblywoman Considine.
Thank you, Madam Chair, and thank you for bringing this bill. My original question was covered a lot by my colleague in Department 6, but it's led me to another question. You mentioned that if there is ahead of time cancellations or notifications of cancellations, that with the tablets, the incarcerated person would have one phone call per day to notify the family. But what I want to know is is there a policy, or will there be a policy when the tablets go into effect, that if visitation is canceled for no cause, the cause wasn't by the incarcerated person, will they be able to notify their family either through text or a phone call without cost, or is it only if they haven't already made a phone call that day? And I'm kind of thinking of a situation where they've already had a phone call to their family member, and several hours later something happens that's going to be canceled. And I just want to know where that policy will be or is already.
James Rennet for the record. Well, the policy has not been developed yet because we got to get the authority to do wireless devices. A company was already selected called ViaPath for the contract for the wireless devices and all communications. But you're correct, if they've already made their one phone call and the visits end up getting canceled on another shift, a later shift, they would not be able to make another one free phone call. You're correct. There would have to be some policy in place that through the website that it would be notified that way. Emails are not going to be free, so they're not going to be able to send an email like that to a family member to notify them. But there are ways to do it through phone, even communication, having and there's no policy about this right now, but you could do a recorded messages. It's that simple, that somebody could always call into and know when something's canceled or going on.
Thank you for that. And I love the recorded message. I mean, many of us grew up on thinking that was advanced technology. So, and depending on where people are traveling from, we don't want people traveling, but the ability to even call in is great and just hear that message. So, of course, website, people want that updated, fancy way, but I think even a recorded message would be swell. We have another question from Assemblywoman Hardy.
Thank you, Chair. Good morning to you. So kind of what through this discussion I think I'm gathering is the intent of the bill, this bill would be to establish the regulations as far as, the visit frequency and all that. That would lay it out. Because what I think I'm understanding is currently either there aren't such set policies or there are, but they're not being implemented or consistently, so that would be the intention of the bill, is to set that, it's in statute, you know, this is what we have to abide by. And then the ombudsman would be a step when those policies aren't followed. So do I understand that correctly?
Nick Sheepak for the record. So, yes, the original intent of the bill was to heavily, through statute, regulate visitation policy because we found ourselves in a position where it was basically mass confusion, right? And so the response to such confusion was, let's go and regulate the Department of Corrections visitation policy. Right now, they have broad authority to develop their own process. Since then, Return Strong, other stakeholders have worked directly with the director to ensure that we have a policy for visitation that will go through the Board of Prison Commissioners. Hopefully, again, there's other legislation, but it will go through the 233B process at some time, the public rulemaking process. Will then be a publicly available regulation, an administrative regulation. And because we are moving along so far in that process, and we do have faith in that process, the idea to make this bill an ombudsman bill is to ensure that that process is followed both by this department and by departments and by administrations that follow this administration. Does that answer your question? Okay.
Thank you so much for that. With that, I don't see any additional questions from members, so I will open it up for testimony. So starting here in Carson City, if there's anyone that would like to testify in support of Assembly Bill 452.
Tanya Brown, TONJA, BROW, advocates for the inmates and the innocent. We strongly support this bill. I want to give you a little history of the Ombudsman bill. Back in 2007, there were some advocates, Ms. Jones, Ms. Florence Jones, Ms. Pat Hines, Michelle Ravel, myself, and others. And this was something that we had worked on getting an independent ombudsman within the Department of Corrections. Ultimately, it failed the first time, we couldn't get anywhere, but in 2011, the bill did pass, but it became under the Attorney General's office as an ombudsman, and it was never funded. Again, in 2013, I went back to the legislature, asked for why the bill had not passed, and it was due to lack of funding, and to this day. And I believe that I did bring this up to the interim Judiciary Committee last year. Some of you have sat on that, the discussion, when Ms. Hawking gave her presentation. Anyway, we had concerns about the ombudsman, and it has been touched on a little bit here. But we are in support of getting this ombudsman. We would like to be included as a stakeholder because in the conceptual amendment, because we have reached out to no avail on this. But
I'm asking, are you?
We are in support.
Okay.
We are in support absolutely of this bill and the conceptual amendment, and we would like to be a participant in the conceptual amendment because I will tell you, the litigation, there's millions of dollars in litigation that goes out. I have learned, and the other advocates prior to in the last 10 years have learned a lot of things. Most people, inmates, are not allowed to see their file. They can't check for accuracy. There's information dealing with litigation in these files. And when the parole board looks at this, they see this, they have no way of knowing whether that litigation, or if there was litigation from a grievance that had been filed, if the inmate was successful. So that remains in the files.
Okay,
Ms.
Ms.
This is some of
Brown.
the concerns that we have, but we would like to be a part of this upcoming, and we ask that Return Strong reach out to us and the other stakeholders because we do have valuable information that should be included in an ombudsman. Thank you.
Thank you.
Good morning, Chair, members of the committee. Erica Roth, ERICAROTH, on behalf of the Washoe County Public Defender's Office in support of AB 452 this morning. Prison-imposed barriers to family contact contradict decades of social science research showing associations between family contact and outcomes, including in-prison behavior, measures of health, and reconviction after release. This is why the American Correctional Association supports in-person visitation, and this bill is both moral and practical, and we urge your support. Thank you.
Thank you, Madam Chair. John Pure from the Clark County Public Defender's Office. 80% of the people plus that go in are going to come out, and we have to decide how we want them to come out. Family visitation is one of the best measures to track connection to your community and success when you re-enter society. We cannot treat people like animals in cages and then expect them to come out better when it's time and reintegrate into society. This bill will aid in rehabilitation. This bill will aid in visitation. This bill will aid in community connection, and hopefully it will aid later on down the road with making amends to the community. So we strongly urge its support. Thank you.
Is there anyone else here in Carson City in support of Assembly Bill 452? Not seeing anyone. Is there anyone there in Las Vegas?
Good morning. My name is Sonia Williams, SONYAWILLIAMS. With me is my daughter Jaselyn, JASELYN, Newman, NEWMAN. We just want to show our support for AB 452 with the amendments, and that's because we have had lots of issues with her father passing. So it's great. We appreciate it, and we're in support with the amendments. Thank you.
Jaselyn, do you have something to say? Are you going to support Jaselyn? You can. Come on.
I support.
Thank you so much. Nah, not this time. Not seeing anyone else in Las Vegas. Is there anyone, well, I should say, broadcasting, can you please open the phone lines?
To testify in support to Assembly Bill 452, please press star 9 now to take your place in the queue. Caller with the last 3 digits 036, please press star 6 to unmute your phone.
Good morning. My name is Ashley Gaddis, Gaddis, and I have been formerly incarcerated at Florence McClure and now a staff member with Return Strong. I strongly support this bill and feel that having this process in place would, like already said, alleviate a lot of frustration and anxiety within the prison. I support AB 452 as amended.
Thank you for that. Next caller.
Good morning. My name is Denise Bolaños, DENISE BOLANOS. And I would just like to say that I do support this bill with its amendments, and I urge you to do the same. Thank you.
There are no other callers choosing to testify in support at this time.
Thank you so much, broadcasting. With that, I will open it up for anyone who would like to testify in opposition of Assembly Bill 452. Starting here in Carson City. Not seeing anyone. Is there anyone in Las Vegas that would like to testify in opposition? Not seeing anyone. Broadcasting, is there anyone on the line?
To testify in opposition of Assembly Bill 452, please press star 9 now to take your place in the queue. There are no callers choosing to testify in opposition at this time.
Thank you, Broadcasting. Is there anyone here in Carson City that would like to testify in neutral?
Good morning, Madam Chair Miller and members of the committee. Darrell Brown, for the record, United Veterans Legislative Council, representing Vietnam Veterans of America, Carson Area, Chapter 388. Although 452 is not veteran-specific, everyone pretty much knows there are a lot of veterans incarcerated throughout the state of Nevada. This could go a long way to adding extreme benefits that be very beneficial to all incarcerated, especially those that we know of are veterans incarcerated. UVLC has not taken a position on this at this time, but as it moves through the process, we may take a position on it. Thank you, Madam Chair.
Good morning, Chair Miller, distinguished committee. Assemblywoman Newby, thank you for bringing this legislation forward. I would just like to say, for the record, Harold Wickham, Deputy Director, Nevada Department of Corrections. I think that this bill, as amended, would provide a great deal of benefit to not only the community, to the stakeholders, but also to our agency. I know it sounds a little confusing going from specifically a visitation bill to now an ombudsperson bill. But I think we've garnered some trust working with Return Strong as well as fines and fees, and we are making massive reform to our visitation regulations as it is, and this would just hold the department accountable. So for the record, we are in neutral for this bill. Thank you again.
Thank you for your neutral testimony. Is there anyone else here in Carson City in neutral? Not seeing any. Is there anyone in Las Vegas in neutral? Broadcasting, will you open the lines, please?
To testify in neutral for Assembly Bill 452, please press star 9 now to take your place in the queue. There are no callers choosing to testify in neutral at this time.
Thank you for that. Then I will close testimony and welcome the bill presenters up for brief closing remarks.
Thank you. Thank you, Madam Chairwoman Sabra Newby, Assembly District 10, for the record. And thank you for your patience and grace with us this morning in the presentation of this bill. As you can tell, there's a lot of passion on this subject, and I pledge, if it's all right with the chairwoman, to work with the various parties surrounding this bill to get us to a point that we can have something presentable and passable for you. Thank you.
Nick Sheepak, Board President of Return Strong and State Deputy Director of Fines and Fees Justice Center. Very briefly, I just want to say thank you again to reiterate for your patience with this. One of the very first conversations I ever had with Ms. Hawking when she started this work in the state was, can we get some sort of ombudsperson? Because today the problem is visitation, and tomorrow it's medical care, and the next day it's something else. And it was always told to us that it was somewhat of a pipe dream. However, through discussions with the department and various stakeholders, this seems like a real possibility. And so we are happy to talk with any and every one of you, and we will work diligently to ensure that you have something in front of you that is usable. Thank you.
Jody Hawking, Founder and Executive Director of Return Strong, and I just want to thank everybody that's been involved for your questions, for your concerns about the change of avenue, which I understand the change of our path. But just in closing, we appreciate all of you, and that I do really believe that this is the pathway that not only allows us to hold, have a degree of accountability around visitation, but really around safety and humanity for people that are in Nevada prisons. And so I think in the larger interest, this is the way to go. And I appreciate working with all of you, and we will hopefully be back with much more detailed language.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 452. The last item on our agenda today is public comment. If there's anyone here in Carson City that would like to make public comment, not about the bill, but about anything else under the purview of this committee, please come forward. Not seeing anyone in Carson City. Is there anyone in Las Vegas that would like to make public comment? Not seeing anyone. Broadcasting, is there anyone on the line that would like to make public comment?
To provide public comment, please press star 9 now to take your place in the queue.
Anne Marie Grant, ANNEMARIEGRANT. My brother Thomas Purdy was murdered by Reno Police and Washoe County Sheriff's Office during a mental health crisis. I remember so vividly walking into the ICU to see my big brother, my best friend and confidant, laying lifeless in a hospital bed connected to all kinds of machines, wires, and tubes down his throat, keeping his heart pumping. I remember becoming physically ill at the condition my brother was in. Contusions on his head, leg, arms, and hands, once perfect hands and ankles now unrecognizable to me due to the swelling from the handcuffs that had been used on his legs and hands to hog tie them and connect them to each other behind his back like he was some wild animal instead of a human being in crisis. I remember the violent retching in my stomach as I became physically sick at the sight of him. I remember seeing my dad cry for the first time ever in my life, and worst of all, question what he had done wrong for this to happen to my brother. The guilt and grief each and every one of my family carries because we could not save Thomas from law enforcement haunts us daily. My family had so many questions, including myself, that haunted me for months and months. No truth was provided to my family by police. The police narrative of lies told to us by Sparks Police Detective Dorothy Peterson was that he was talking crazy and suddenly stopped breathing. I had so many questions. Was he afraid? Did he know what was happening? How could he have just stopped breathing? Did he ask for help? What was he thinking about as he realized, and indeed, his pleas for medical attention and decency would go unheeded? Did he think about his children, about me, my dad? Was he hoping one of the 10 law enforcement officers who did this to him would come to their senses? The questions and others plagued me until we finally discovered the truth, which only led me to more unanswered questions. Did he wonder if his killers would be held accountable for their actions? Had this happened to others? Why were law enforcement covering up for each other? Sadly, I found out this is the MO when law enforcement kill your unarmed, mentally ill loved one.
Ma'am, can you wrap up your public
Please
comment?
support SB. Yes.
Oh, remember, you're not mentioning a bill. This is just,
SB.
no bill mentions,
Yes,
ma'am.
I'm mentioning a bill that wasn't heard today. Please
But it's not
support
even in
SB
our house.
362.
Okay, thank you.
Okay,
Thank
they're quite rude to cut me off.
You had.
You don't even know what bill I'm trying to talk about.
Okay, thank you, ma'am. All right, with that, members, we have concluded public comment, and we are done with our business for today. I know this seemed like a long week. Next week is going to be worse. So please make sure you get a lot of sleep this weekend. We will see you at 8 a.m. on Monday morning. This meeting is adjourned.